Good evening, everyone, and welcome to the lecture series for the preparation of CLAT examination 2023. In this lecture series, we are talking about those areas which we are dealing with the legal reasoning, which is perhaps one of the subjects that has to be dealt with when we are preparing for CLAT examination. And it is perhaps the only area where which the students feel that there is a sort of difficulty, and that is perhaps the reason we have come up with this program which we are dealing with the different subjects which are involved in the legal reasoning area of CLAT preparation. As you already know that the CLAT is divided into various subjects that has to be dealt with. Starts with English, legal reasoning, logical reasoning, quantitative aptitude, and there are other areas, general knowledge also. But when we talk about legal reasoning as such, the CLAT consortium has time and again told that the CLAT aspirants are not supposed to actually learn the sections as such, but they should be well aware by the principles that is underlining these legislations. So in the previous series, we have discussed about the law of contracts, which we have talked about the different segments of formations of the contract and how a person can be considered eligible to form a contract, and how a contract can be vitiated, how a contract comes to an end, and everything related to formation of contract between two individuals or two legal entities has been discussed so far. In our previous video, we have started with another subject which is related to legal reasoning, and that is the criminal law. And in the criminal law, there is a subdivision which we are going to learn three major subjects. One is the Indian Penal Code, second being the Code of Criminal Procedure, and the third being the Indian Evidence Act. All these three laws come in handy whenever there are questions which is related to any crimes in the CLAT examination. And so it is obviously recommended for all the CLAT aspirants to have a good glimpse of what are the underlying principles. And once they have acquainted with these principles, they can obviously apply those principles in the question that will be asked. As you already know that the CLAT examination will be in the form of passages. So there are chances that you will be getting a passage form of question which there will be a fact that will be in front of you, and the laws and the principles that are underlining these legislations has to be applied so that the questions, the problems which is there can be solved. So it is important requisite that the candidates who are preparing for CLAT examination are well aware with these principles. And so accordingly, we have started with our Indian Penal Code, which we have discussed about the various principles that one has to take into consideration. We have talked about the latent maxims, actus reus and mens rea, which we have discussed that in order to constitute a crime, both the elements of actus reus and mens rea should be important. Then we have discussed about the general definitions which is there, which one candidate is expected to understand that what act will actually constitute a crime. And in order to understand that, it is important that we go through the important provisions of this act. We are not supposed to learn the definitions as such. We are not supposed to retain the sections as such, because that is something that obviously we will be doing in our college areas when we will be in the college. But during a competitive examination, all you need to understand is the underlying principles. The questions that will be there in your question paper will be in a paragraphical form, where facts will be there, and in those facts, the principles that will be applied has to be understood with understanding the general exceptions, which if there is an act which through the facts we are getting an understanding that it is actually a crime that has been committed. But if we go through the general exceptions and we apply those general exceptions in that particular fact, we see through it that the general exception is also getting attracted. In that scenario, the crime which prima facie, the act which prima facie so that it is a crime that has been committed in a society, but due to the presence of these general exceptions, the person who has been the accused will not be considered uh, the main will not be considered as the accused. Rather, he will be uh, freed. He will not be convicted. The reason being, it is falling within the general exceptions. I have explained it to you all the general exceptions in our previous video. So I suppose that we have understood that under which conditions a person, even though the act suggests that it is a crime, but he cannot be held guilty because it is falling within the provisions of general exceptions of the Indian Penal Code. For example, if a person, being a doctor, is treating somebody and during that treatment the person dies, so we cannot claim that that particular act of the doctor is a malicious act or an act which can constitute to be a crime. Because as we know that there is an underlying principle that we have already discussed, actus reus plus mens rea is equals to crime. So here, although the person can say that the act the act is not up to the mark or not in good faith, but when we say that it is the general duty of the doctor to do it, and doctor had but no intentions to kill the other person, then the mens rea is not at all present, and that is why take into consideration the general exceptions also, the doctor will not be held liable for murder. So in this way we have to understand that general exception plays a very important role in whenever there will be question which is in relation to Indian Penal Code or constitution of crime, and the facts will be there. So it is obviously advised, and I'm telling you again and again repeatedly, that one should be very clear about the general exceptions. The section starts from section 76 and ends till 106 of this act. And so far we have already completed those sections. If you want to understand that, you can obviously refer to the previous videos that are there. In today's lecture, we will be discussing one case with the name of Deadly versus Stephen, which is an important case, and it is in relation to the general exceptions that we have studied. And why we are discussing it, because there are chances that the facts that were there in the in that particular case will be there in your question paper in another form. Maybe the characters might be changed, but if you have understood the factual description of that case and you know what the judgment is, so you obviously will understand the principle and you can apply that principle in your answers. Okay, so I'll just show you the screen. I suppose the act is visible to you guys, and what we are discussing here is the case. I just 1 minute. Yes, we are talking of this particular act to cause harm, but done with criminal intent, and to prevent, done without criminal intent, and to prevent other harm. We will just go to the section for a better understanding. So these are the general definitions of the act. I suppose you are not. We are not supposed to go through these definitions. Obviously, this is something that you will be studying in your college days when you will be studying Indian Penal Code in detail. Yes, this is something that we have already studied yesterday. And we are talking about the sections of act likely to cause harm but done without criminal intent and to prevent other harm. Okay. So as you can see the screen, this is an act likely to cause harm but done without criminal intent and to prevent other harm. We have discussed that there are two situations where there are majority of the people who are going from a bus, and there are two people who are going by cycle, and there is a condition where there is a road, and on the road one side there is a cycle with 2 passengers, and then there is a bus with 30-40 passengers, and there is a truck which is being driven by the accused. And he comes to a situation that he is at that speed, maybe let's say 100 km/h, and the accident is inevitable. Either he has to either he should turn the truck towards the direction of the cycle, or he should turn the truck towards the direction of the bus in order to avoid the accident. But any which ways, the accident has to take place. So if the truck driver, without any guilty intention or mind, it is an important requisite to remember that there shouldn't be any guilty intention. Yes, see, that has been written, done without the criminal intent. That there shouldn't be any criminal intent as such. And he drives with good faith, but in order to save the majority of the people, the truck runs over the vehicle, over the passengers of the cycle. And in that particular act, if it is not done without the criminal intention and in good faith for the purpose of preventing or avoiding other harm to a person or property, then this particular act will be considered as an accident and not rather as a crime. We can see the illustration if for your better understanding, and it will be very much helpful for you, that there was this illustrations, and I would like to tell you here, guys, that in all the acts that we are going to study and we have studied so far, you have illustrations, and the majority of the questions that you will see in your competitive examinations are actually through these illustrations only. Because once you have understood the concept and once you have seen that how this concept is being applied in this particular illustration, then you can understand that the questions that will be there will obviously be similar or familiar to these particular illustrations. So it is always advisable that whenever you are preparing for CLAT competitive examination or any competitive examinations, understanding principle is good, but once you are acquainted with the illustrations and the example that is given, you will have a clear picture as to when a particular act, if done, can be considered as a crime or not. So the act provides these illustrations, and just we are going to read it so that you can also get understanding of the particular exception that is there. And that says that A. So A is a person here, the captain of a steam vessel. So he is the captain of a steam vessel, suddenly and without any fault or negligence on his part. So now we have to be very much clear that there shouldn't be any negligent act. So one important requisite that we understood from this particular illustration is that it shouldn't be any negligent act. We cannot say, and we cannot take this excuse that, okay, there was this neglect. Okay, so if we cannot say that we were driving at a speed of 180, and now there was a situation where which there on the right hand side there was a cyclist, on the left hand side there was a bus, and because of the high speed we were not able to continue. We were not able to stop the truck, and rather the truck hit the bus or maybe the cyclist, and because of that particular incident, the people have sustained injuries. We cannot take that, but we cannot take that defense. We have to make sure that our act should not be any negligent act or any fault on our side. This is a very important requisite, and you need to remember this particular thing whenever there will be any factual questions that will be in front of you. So there should be any negligent act. Apart from that, without any fault or negligence on his part. Okay, so A is the person who's the captain, which we are suggesting that if there is no fault or negligence on his part, he finds himself in such a position. Okay, now he is in such a position that before he can stop his vessel, before he can stop the vessel or he can stop the vehicle, the must inevitably run down a boat B. So either it will be passing through a boat B with 20 or 30 passengers on the boat. So there is a boat. So I'll just try to show it through a diagrammatic representation. So let's take the example that this is a ship. Okay, I'm not good in drawing, so I'm so sorry, guys. So this is a ship, and on the one side there is a boat, which there are around 20 passengers, and there is another boat. Here is another boat. Okay. This is one boat. And here you have another boat. Okay, and there are only 2 passengers in this. So now the captain of this vessel, on seeing his position, that either this ship so this is the ship. So either this ship is going to hit this boat or this boat in order to avoid accident. So now on board, unless he changes the course of his vessel, and that by changing his course, he must incur risk of running down a boat C with only 2 passengers on board, which he may possibly clear. So now it is not like that this particular captain, the captain of this ship B, has intentionally wants to hit this particular boat, but he thinks that if he'll turn the vessel in this particular direction, then there are chances that the accident can be avoided. So taking into this consideration, B, if he turns his boat in this particular direction and tries to clear the area, but during the clearing of this particular area, so as to avoid the accident, hits this boat, because of which these 2 passengers sustains injury, then by virtue of this particular section 81, the captain of the vessel B will get immunity and he will not be charged of any offense. Understood, guys? So here, if A alters his course, so I'm so sorry, it's not B, this is A actually. A, right? So if A alters his course without any intention to run down the boat C and in good faith for the purpose of avoiding the danger to the passenger in boat B, he is not guilty of an offense. He is not guilty of an offense, although he run down the boat C by doing an act which he knew was likely to cause that effect. If it to be found as a matter of fact that the danger was which he intended to avoid was of such a nature that has to excuse him in incurring the risk running down C. So you get the point that we have understood that this particularly tells us that if there is an inevitable accident, section 81 talks about inevitable accidents. So if we have understood that if there is by any chance there is an accident that has to take place, so one should act in such a way and in good faith in order to minimize the accident. So if there is any act which has been done during that course, even though it prima facie feels like that the crime has been committed, we have to see that whether the accident that has happened was with the intentions of with a criminal intention, or it was done in order to prevent much greater loss. So by this example, I suppose you have understood section 81. Now we are coming back why we have studied this particular thing, because we need to study one important case law, and that is Dudley versus Stephens, which says that necessity cannot be used to avoid criminal charges. So you have just seen this illustration, and the facts of Dudley versus Stephens is all perhaps all those are also the same. So there was a ship that was carrying 4 people, and that particular ship, there was Dudley and there was Stephens. So Dudley and Stephens were on the boat, and they went to the high sea, and there were four passengers, one being Dudley, second being Stephens, and then there was third person who was the cleaner, and then there was one other person, or what we call is a boy, and that particularly the boy was doing the cleaning portions of the ship. He was involved in cleaning the ship. Now, what happened was that since the ship was in high seas, they had no food left, and there was nothing on which they can survive. Neither they had drinking water. So, what happened was that all of four were starving. So, Dudley came up with this idea, stating that in order to survive, what we need to do is that we need to draw a lot in which, if whomsoever name comes up, should be killed, and on his flesh we can survive for another time period. So it was actually Stephens who accepted that particular idea of Dudley and stated that I am okay with this particular thing to happen. The other person, the second person, who was also present on that boat, didn't allow the same. They said that no, perhaps it shouldn't be the way forward. And the fourth boy, who was being the cleaner, was never consulted. And after that, they made up the plan. And what they did was they killed the boy, and they ate the flesh, and they survived eventually for another 4 days. But after that particular survival, they were rescued, and immediately they were taken into custody for killing the boy and surviving on his flesh. When the matter went up to the court, Dudley came up with the defense of stating that since we were starving and we had but no other option, and we have to survive any which ways, so we together we decided that we will be killing the boy and we will be eating, because had been that scenario that we would have not killed that guy, we all would have died. And it is perhaps because of the necessity we had to take that step. So the matter in issue in front of the court was whether necessity can be taken as a ground to avoid criminal charges. That because of necessity, because of the survival, we had but no other option to kill the boy. The court rejected this particular claim, stating that necessity cannot be a ground to do a particular act. You would have avoided this act by starving. Maybe the chances were that you could have rescued for another within maybe 24 hours, or you would have found some other way forward. But killing is not the solution for the same, because the boy had also the right to survive. It could have been you also would have died, but instead you planned to kill the boy, which clearly shows your intentions to malified intentions to kill the boy and to survive any which ways. So rather it is not necessity but your bad faith. So the claims of and the defense of necessity in order to avoid criminal charges what was not entertained by the court, and the court said that Dudley and Stephens should be punished for the same. So that is why this case is important, because you might get questions in regards to the same, that necessity being a phenomena, and stating that because of necessity the act was done. And majority of the students take the emotional ground, and they on the moral grounds they start taking the wrong judgments. But one has to be very much clear and very much clear about the facts that whenever these type of factual information has been given to you, you need not get emotional, you need not think morally. It has been seen that majority of the students get emotional and they take decisions morally and on emotional grounds, but law doesn't work like that. You have to be very much clear about the facts that are there, and based on those facts only you have to work and provide the information and the answers. So I suppose this particular case law is clear to you. Now, as I've already informed you that we have gone through all the exceptions that is there, I suppose this exceptions part has been completed. Yes. Now, this particular thing we have already studied, or act causing slight harm. This is also enough of that for some petty acts, we don't resort to courts. Yes, I misplaced my pencil. Can I go to the court and say that my pencil has been misplaced and I accuse Mr. XYZ that he has stolen my pencil? The court will say that, see, we have a lot of tasks that we need to complete, and this is a very small thing. Uh, Entertainment of such things cannot be we cannot entertain such things from happening in the court. Nothing is an offense by reasons that it causes or that is intended to cause or that is known to be likely to cause any harm if that harm is so slight that no person in orderly sense or temper would complain of such harm. For example, there is one friend of mine who is just standing beside me, and what he did, he just with a small slight push, he patted on my head. Okay, and that too in front of my 300 students. So although this is particularly a thing which I was not there was no harm that was caused to me, and he just did like this. So I don't feel like that I can go to the court and file a case against him for hurt, that he has hurt me, and that perhaps is best example for you people to understand that whenever there is a slight small act, we are not supposed to go to the court and file a complaint against that, because the court will not take it to consideration, because there is a no crime. Okay, that is something that we have already discussed. Right to private defense we have already discussed. We have discussed to what extent we can use the right of private defense of to kill somebody, when the right of private defense of the body extends to causing death. We have studied that there are perhaps some common grounds over which we can uh, even kill somebody if there is a if we are utilizing our it on the basis of defense, that somebody is committing rape. If somebody is intending of committing rape, we can kill that person in the right of private defense. So it's not like that if but the only requisite, the only principle that you need to remember is the principle is, and we have studied that in section 96, which is nothing is an offense which is done in exercise of right to private defense. The first and the foremost thing that you need to remember is that there is no right to private defense against an act which does not reasonably cause the apprehension of death or of grievous hurt, if done or attempted to be done by a public servant acting in good faith. So the apprehension of death and grievous hurt under the restriction mentioned on the last proceeding to the voluntary causing of death or any harm to the assailant, if the offense which occasions exercise of the right be of any description herein enumerated, namely. Now, if an assault may be reasonably cause the apprehension that that will otherwise be consequence of such assault. So if there is an assault where which an apprehension of death is there, then you can even kill the other person by using your right to private defense. Such an assault may reasonably cause the apprehension that grievous hurt. Now, one is hurt, second one is grievous hurt. Then intending to commit rape. If you have that assault where which there is an intention to commit rape and the apprehension of death is there, then the person can even be killed. Same goes with the fourth section, subclause, fifth, sixth, and seventh. Administration of the asset. This has recently been added by the Act of 13 of 2020. This was an amendment which was brought by Justice Verma committee report and brought about an amendment for whole criminal law. Act 13 of 2013. So this particularly added that even if somebody has thrown or administered acid, then also we can use our right to private defense to kill that person. If we have apprehension that if this particular thing has not been done, it will adversely affect our stand. So if these acts are being happening, the right to private defense can extend to causing death. And same goes for property also. If there is a robbery, housebreaking, mischief by fire, theft, mischief, or house trespass under such circumstances as may reasonably cause apprehension that death or grievous hurt will be the consequence if such right of private defense is not exercised. For example, there is a house burglary and there are 4 or 5 robbers who have entered into the house, and your family is there. And there is apprehension that if you move or you do something, that then these robbers or unlawful and persons who have entered your house will administer or will cause you hurt or grievous hurt to you or to your family. Then you have the right to private defense, which extend to even killing those intruders in order to save your life. This is the exception that has been mentioned. Let's suppose we have already discussed these things, but just wanted to for you to get a clearer idea. And now we have to and come along with this particular thing, what is abatement, because abatement is also important portion, because once you have understood there might be some questions in regards to abatement also. So what does abatement means? So in a simple layman terms, what you can understand abatement is nothing but assistance, help, or support. If you assist somebody for doing illegal act, then you becomes abater. And you can also be punished for the same offense as you have done it by yourself. So for example, there is one friend of mine who I have strong beliefs that is jealous of a person with the name of Rahul. And what I do is I tell him that Rahul was actually telling very bad things about you. He was defaming you in public, and he even told me that if my friend would act in any inappropriate manner, Rahul can even inflict injuries to him. So by this provocation, I actually asked my friend that, and my friend is so jealous of him that he really wishes to, attack or cause grievous hurt to Rahul. And by such instigation from my side, what my friend did, he went to Rahul's house and he grievously started beating Rahul. So now, the point is, the court may see that why such act has been done. And when all the investigations and everything will be shown into the court, it will come up that I have abated or instigated my friend, because of that instigation, he committed such act. So it will not be only Rahul, it will not be only my friend who will be punished for such action, but rather it will be me also who will be punished for abatement of such crime. So if the first and the foremost point when we talk about abatement is that it is an instigation, instigates any person to do that thing, engages with one or more other person or persons in any conspiracy for the doing of that thing, if an act or illegal omission takes place in pursuance of that conspiracy and in order to doing that thing. Now this particularly means that you are also involved. So if somebody tries up, if somebody feel that they are planning to rob a bank, and in pursuance of that robbing the bank, they planned a conspiracy where which they decided that out of the 5 people who have conspired for robbing the bank, one will be inside the car waiting for the rest of the 4 to rob the bank, and then immediately come up with the looted items, and they will sit inside the car and then they will leave. And in that particularly, the one person who has been standing outside also conspired for this particular plan. So it will be considered that all of them have abated for that particular illegal act of their own, and each one of them will be held liable. Okay. Now the third one is intentionally aids by an illegal act or omission the doing of that thing. Now, if I see that there are 2 persons who are fighting, okay, who are fighting, and I, being the bystander, standing there, seeing them fight, I have grudges with this person B. Let's take the example. This is A, this is B, and I have grudges with B. So in order to assist A and take vengeance from B, what I do is I provided A with a knife, and during that fight, A inflicted injuries through that knife, and because of which B died. Now, this particularly shows that what I did was I did an act in order to assist A to kill B, and in this particular assistance, because of this particular assistance, B died. So I will be considered as the abater of the illegal thing that has been done. A person who willfully misrepresent or by willful concealment of a material fact which he is bound to disclose voluntarily causes or procures or attempt to cause or procures a thing to be done is said to instigate the doing of the thing. So this take an example. A public officer is authorized by a warrant from a court of justice to apprehend Z. Okay. So there is a public officer. Let's take an example. A is a policeman. He was given order by the court to arrest Z. B, knowing that fact and also that C is not Z. So there is one person B to whom A asks that is this Z? This one person C. So A asks to B whether this person is Z or not. B, in order to let Z abscond or run away, says to A that this C is Z. Okay, knowing the fact and also that C is not Z, willfully represents that to A that C is Z, and thereby intentionally causes A to apprehend C. Here B abates by instigation the apprehension of C. Yes, so even if it is a public officer who might not be considered to have committed a crime, because he acted in good faith. Yes, because what he was doing was under the order of the court. Yes, and we have studied in our previous exceptions. Yes, in our previous exceptions, we have studied that act done by a person bound or by mistake of law, believing himself bound by law. So if that act has been done by the public servant, even though the public servant has not committed any crime, but here in this particular illustration, B, who has represented that C is Z, is actually committing a crime, which is apprehension of C. Now, C has been wrongfully confined by A, the public officer, and because of act of whom? Because of the act of C. So now, what actually has been done here is that C has by the act of B. What actually has been done here is that C was wrongfully confined. Wrongfully confined because he has been apprehended. So now wrongful confinement is an offense according to IPC. So now wrongful confined is an offense, but A is being the public officer acting in good faith has not done any offense, but rather C or B, to whom A have asked, the public officer has asked that whether Z is C or not, and he willfully represents that C is actually Z. He has committed an offense, and that offense is said to be abatement to wrongful confinement. Yes. So here, even though the public officer will not be considered to have committed an offense, but B shall be considered that he has committed an offense, and that is abatement of wrongful confinement. So here B will be punished in the same manner as if he has committed wrongful confinement of C. I suppose you have understood that how exactly these particular exceptions will come up handy for you whenever you will be solving the questions. The important case of Dudley versus Stephens is perhaps very important for you to understand, because necessity cannot be claimed as a defense whenever there will be an illegal act. You cannot say that because of the necessity, I have done this particular act and I should be freed. So we have understood abatement also, because abatement is perhaps also very important. You will be seeing that the person who is abating a thing there are chances that he can be punished, and the main accused might not be punished. But whenever the main accused will be punished, it is clear that the abater shall also be punished. So there are chances that whenever I've just given you this particular illustration which we saw that the public officer shall not be convicted, will not be convicted for an offense because he has done the work in good faith, but rather B will be convicted for an offense of abatement of wrongful confinement because he intentionally willfully represented C, that C is Z, and because of that willful intentions, C was wrongfully confined. Understood? So that is very important for you to understand. Now under section 108, it has been defined what is an abater. We will just see this illustration. A instigates B to murder C. B refuses to do so. Okay? A is guilty of abating B to commit murder. Yes, in the same way, if somebody has instigated, in my previous example, when I was telling my friend has some jealousy with Rahul and I instigated my friend, because of that instigation, my friend started beating Rahul, then obviously both of us will be considered to be liable. But if my friend happens that if my friend says to me that it's fine, whatever he wants to say, I don't care. But rather Rahul comes to know that I was instigating my friend to act in such a manner, then that particularly will be considered as abatement and I can be punished for that particular act also. So A instigates B to murder D. B, in pursuance of the instigation, stabs D. D recovers from the wound. A is guilty of instigating B to commit murder. So here I will be, if here A instigates B, right? So here A will be tried for abatement of murder, and D rather will only be charged for grievous hurt or attempt to murder. So here what we understood is that abating something can be considered as a more heinous offense, because what we are doing is we have the guilty intention. The person who is abating has the guilty intention, and because of that instigation, he is using somebody else to do that particular act in order to save him from being the main accused. Then it is considered to be a more heinous offense, and that is perhaps the reason an abater is always punished even if the main accused is not punished for his act. Yes, so abatement is that we have already studied. If you want to just go through the some principles of it, you can just go through it, but I suppose that will be more than sufficient for you. And with this particularly, we have come to our another chapter, that is criminal conspiracy. So criminal conspiracy is something when somebody conspire, where two or more persons agree to do or cause an illegal act, an act which is not legal by illegal means. For example, an illegal act, I suppose you're clear. An illegal act means killing someone, robbery, etc. An act which is not illegal by illegal means. Selling of clothes is legal act. Yes. But what we do is that we stole clothes from manufacturer and started selling it on road without proper permit. Then it will be considered as illegal means, and such an agreement is designated as a criminal conspiracy. Provided no agreement except an agreement to commit an offense shall amount to a criminal conspiracy unless some act besides the agreement is done by one or more parties to such agreement in pursuance thereof. So here, criminal conspiracy can only be considered once there is an act. If there is no act and only people have conspired, it cannot be termed as criminal conspiracy, because there has to be an act. Until unless there is no act, it won't come within the ambit of criminal conspiracy. So in order to accuse somebody for under section 120B, that is punishment for criminal conspiracy, in order to charge somebody for criminal conspiracy, act should be done. If the act is done, section 120A and B automatically gets attracted. So because criminal conspiracy, guilty mind is there, plus act also has been committed, then it will constitute criminal conspiracy. Yes. And the punishment for the same is whoever is a party to criminal conspiracy to commit an offense punishable with death, imprisonment of life, or imprisonment for a term of up to 2 years or upwards. So any offense where punishment is greater than 2 years till death punishment, which includes life imprisonment, etc. Be punished in the same manner as it is abated such offense. So whenever there is a conspiracy, then whomsoever is involved in that conspiracy shall be punished as if they have abated the offense. Abatement we have just studied. So whenever there is a criminal conspiracy, then obviously the person shall be punished. Okay, which then what will be the punishment? What the punishment would be? Offense shall be punished with imprisonment of either direction for a term not exceeding 6 months or with fine or both. So punishment of at least 6 months will be there. So now you must be having this particular confusion in your mind, sir. Only for conspiracy we are only we are only giving a punishment of description which is not exceeding 6 months. Then obviously it is. Don't you feel like that it is very less? So I'll tell you, whenever there is any case in real world, so it is not like that the people will be charged for only one particular crime. Because if you see in the practical scenarios, whenever there is a murder being committed, so there are chances that it will attract many sections of Indian Penal Code. It will attract section of grievous hurt also. It will attract sections of hurt also. And in the same manner, if there are 2 or 3 people who have been involved in that particular act, so there are chances that section 120B, section 34, which talks about intention, similar intention, criminal intention, that obviously gets attracted. So whenever the punishment is given, all of the punishments combined, and then we see majority of the time it is not compounded punishment, which it is not like that first 6 months for criminal conspiracy, then again for theft, and then again for murder. You will be getting a separate punishment, but rather the act or the offense which is providing the maximum number of punishment, that will be considered. So it depends on the discretion of the judge whether he wants that the punishment should be compounded, and whether the person who has done the major act of maybe if we talk about murder, so it includes a majority of the actions like criminal conspiracy, grievous hurt and everything. So he will be charged for life imprisonment or life hang till death or death penalty also. So what we see here, that majority of the times the punishment is combined, but there are chances that whenever these sections get attracted, the court may feel that okay, murder has been done, but the person will not be charged for murder, but rather for the grievous hurt. So that is why it becomes important to mention each and every description, to mention each and every term of the punishment whenever we are talking about any crime. So if there is a criminal conspiracy, 6 months. If the conspiracy leads to theft, then obviously the punishment for theft is there. If during the theft grievous hurt is being given, then the punishment of grievous hurt, and during the because of the grievous hurt, if the murder has been done, then the punishment for murder will be taken into consideration. So I suppose you have understood the reasons behind mentioning the punishments for each and every sections, and why that so that some of the areas where you will find mention of less punishment, which according to you might not have been, might be more. And then you have sedition. Sedition is something that you have already might have studied in your earlier days. Sedition is something whereby we are trying to bring into hatred or contempt or exercise attempts to excite disaffection towards the government established by law in India, shall be punished with imprisonment for life, to which fine may be added, or with imprisonment which may extend to 3 years, to which fine which may be added, or with fine. Okay, whosoever by words either spoken or written or by signs or visible representation. So you must be having this confusion, sir. Then why is it so that the news channels are actually criticizing the government? Then obviously they will be considered doing anything which is called as which can be considered to be sedition. The answer is the expression disaffection includes disloyalty and all feeling of enmity. Okay, comments expressing preparation of the administration or other actions of the government without exciting or attempting to excite hatred, contempt, or disaffection do not constitute an offense under this section. So this becomes an explanation or exception, and that is why the news channels are actually able to criticize the government of the government policies, because until unless it also plays an important role. We have the fundamental right to freedom of expression and speech, and whenever we have in the democracy, it is the right of the opposition and of the citizens to criticize the government if they have uh, done something which is disappropriate and it is of not no benefit towards the citizens of India. So the sedition has to be just understood, because you might not get questions over the same, but there are chances. So that is why you should understand that the if we are attempting, if there is comments expressing disapprobation of administration. So if we are not satisfied by the work of the government and if we are criticizing on the basis of that, it will not be considered sedition. But going to foreign countries and saying that the government is not the government is a thief, or government is doing criminal acts, all the members of the governments are actually criminals. So these type of words and actions will amount to sedition. So you need to have a clear-cut understanding what exactly is the difference between sedition and criticizing the government. Now we have completed all the major areas of the Indian Penal Code, which we are just now confined towards the offences which are mentioned under the different chapters. And the only important provisions that we have to discuss are starting with chapter 16th, I suppose. Chapter 16, which talks about offences against the body. I am just scrolling it down so that we can see the screen, where which the offences of culpable homicide, murder, and everything has been written. Yes. So we have completed all the important provisions which are important for your CLAT preparation. Now we will start with our chapter 16, and then we will be moving forward with the other chapters which are important. But this perhaps becomes a very important portion for your CLAT preparation. You might get questions. What is culpable homicide here? Culpable homicide here means human killing. So human killing in Latin terminology is known as culpable homicide. Culpable homicide. Home means killing. Homi means human, and side means killing. And culpable means willful. So basically, if we take into consideration the whole meaning of culpable homicide in a layman terminology, so that it becomes clearer for everybody to understand. So basically, culpable homicide is actually nothing but willful killing of human. Okay? Whoever causes death by doing an act with the intention. So when we say with the intention, it means willfully. Of causing death, intention of causing death, or with the intention of causing such bodily injury as is likely to cause death. Causing death or with the intention of causing such bodily injury as is likely to cause death, or with the knowledge that he is likely by such act to cause death, commits the offense of culpable homicide. So you can see that there are three requisites. First is intention to cause death. Then you have bodily injury that will amount to death. And then you have knowledge that such act will cause death. Commits what? They commit culpable homicide. It means that when you talk about murder, murder is also nothing but culpable homicide. Then why is it so that murder has been defined separately in culpable homicide? Because there are chances that even though the intention was there to kill the other person, the intention was there to do an act with the intention to do the murder, but the chances are that the person might have not died. Then whether the person can be charged for murder or charged for culpable homicide, that is something that we will be understanding. But since it is a long chapter, since it is a very important yet interesting topic, we need clear mind, and that is perhaps the reason we will be continuing this portion in our next lecture. That lecture will be only restricted towards understanding the difference between culpable homicide and murder, and then the remaining offenses which is related to the human body, and then we will move to the offenses against the property. With that, we will be completing our syllabus for criminal laws IPC. In the next chapter, in the next upcoming videos, we will be studying about CRPC and Evidence Act. So I suppose we are going to discuss culpable homicide and murder, the difference between them, in our next video. You are supposed to just go through the definitions that has been mentioned under the different sections of culpable homicide and murder, and you will see a very similar definitions of both of the things. Then what exactly is the underlying difference? That is something that we will be discussing in our upcoming lecture. With that, I will request you to kindly continue with the reading of the subjects and continuously start practicing the previous year question papers. And after understanding the different principles that, for example, we have studied about Ridley versus Stephens, which talks about necessity, and the general exceptions that we have already studied so far, it is important for you to go through the question papers or the mock test papers that you have with you. Just try to solve them by applying these principles and see to it that how many questions you are able to match the answers correctly. Okay. Let's meet up in our upcoming lectures. Thank you so much for your patience hearing. Take care, guys. Bye-bye.